Thank you for joining our California Developments webinar. I'm pleased to be joined by my colleague, Megan Shaked, from our California practice. I'm Andrew Sommer, a managing partner of the California practice. This is a webinar that we proudly do every year in California to apprise clients of developments in California law, particularly from the last legislative session. And in recent years, California has been quite active legislatively with new employment laws. And this year has been a little bit different with the pandemic and COVID-19 related legislation and rulemaking. I am a partner with the California practice, and like Megan, I have a dual practice. My background is in labor and employment law, litigation counseling, and I also advise clients in OSHA matters and various workplace safety issues, which has been particularly relevant this year with COVID. And just the summary, my background is in litigation, individual and collective actions involving a myriad of employment laws. And then I also represent employers in inspections and enforcement proceedings involving OSHA. And then I counsel employers on compliance with a variety of employment laws, primarily focused on California. And then turning over to Megan.
Thanks, Andrew. I'm Megan Shaked. I am an associate in the California office along with Andrew. And I'm a member of the firm's OSHA practice and labor and employment groups. On the OSHA side, I, like Andrew, represent employers during inspections and investigations conducted by OSHA. And on the labor and employment side, handle litigation in California, state and federal courts, handle administrative claims, and also represent and advise employers on all aspects of the employment relationship, including many of the topics we'll be covering and discussing with you all today.
Thank you, Megan. So we wanted to review with you first the agenda for today. We're going to start out with the COVID-19 emergency temporary rule that was adopted by the Cal-OSHA Standards Board effective the end of November. And this has had a significant impact on employers across the board, largely. And then we will discuss specific notice requirements of COVID-19 exposure and cases under a couple different pieces of legislation. And also we will address legislative developments over independent contractors, specifically what is the standard for determining whether an individual is an independent contractor or employee, and what broadened categories have recently been recognized as exceptions to employee status, essentially that they may be properly classified as independent contractors. Then we will discuss wage and hour developments and developments over the no rehire ban that was previously enacted in California. And then to finish this off, there are some developments over leave laws, as well as updates concerning COVID-19 paid leave. So diving right into these issues, the next category involves the Cal-OSHA Emergency Temporary Standard. And we will have a much more extensive webinar just on this subject on January 26th next week. So if you're interested in learning the ins and outs of this standard, please go ahead and sign up for that. You can do that on our website. But this standard took effect November 30th, and it was emergency standard, meaning that there was a very brief rulemaking process extremely brief comment period, and then the rule took effect promptly after it was adopted by the Standards Board in California. And this standard it's a, I think it's a 23-page standard or something like that. It's quite extensive with a number of parts. It apparently was drafted by the Division of Occupational Safety and Health in consultation with public health officials in the state. But given the rush to adopt this rule, there's a number of areas where it's just ambiguous, it's inconsistent, and it's been a real challenge for employers in the state. And so we've been working with businesses on providing guidance on compliance with this new standard. We also are formed an employer coalition to advocate in connection with the standard, particularly areas that were of significant concern to the employment community. And that was a coalition that our firm had formed, and we had spoken in the rulemaking process. The rule that we're left with has a number of different parts to it, and we wanted to cover with you the highlights. Typically in the past, when we work with HR professionals, in-house counsel, there can be the separation of professionals that are focused on workplace safety concerns and others that are focused on just general employment HR specific concerns. With this new standard, it's so pervasive in how it applies and has such significant concern during the pandemic that I'm finding that it's really impacting essentially all workplaces. And so, as we indicate here, the standard applies to all workplaces. Really, the only exceptions are is if you have an employee that's teleworking, they would not be subject to the standard. Also, if you have an employee that's just working alone in the workplace, which would be pretty rare, there wouldn't be coverage. And the last category would be if you are, for example, a healthcare employer where you're already subject to the aerosol transmittable diseases standard. You're considered generally not subject to the ETS standard, the Emergency Temporary Standard. And so what we're working with here is we have the regulation, the standard itself. We have some frequently asked questions that are posted on Cal OSHA's website with answers. That is essentially the guidance that we're working from. That guidance is helpful in understanding how the Division of Occupational Safety and Health might enforce this standard, but it's not having the force and effect of law. And so we're still confined by the regulation and doing our best to read the tea leaves and try to understand how this new standard might be interpreted and enforced. There's also some executive orders. There's one in particular that addresses the time period in which an exposed employee needs to be outside of the workplace with some changes to that benchmark. And so the basic components of this ETS are a requirement that you have a COVID-19 prevention program. And it's a performance standard similar to what we have with the Injury and Illness Prevention Program that basically requires that you have a written program with very specific parts to it and that you comply with certain requirements for how you implement and maintain those requirements. And then there's a separate section addressing outbreaks and major outbreaks, and that's where you have essentially clusters of positive cases during certain periods of time. And lastly, there's requirements that apply to maybe a more limited group of employers. That would be where you are an employer that provides housing to workers, and this may be the case if you are located in a remote setting where there's not adequate housing for workers, such as in agriculture. Or the other area is where you have employer-provided transportation to and from work. That, for example, if you have a shuttle bus, you're taking employees to work, you have very specific requirements that you must comply with. So moving to the next slide, wanted to address with you the specific parts of the written COVID-19 prevention program. And this is probably a good time to mention that we will leave time at the end to answer questions. So if you have any questions, please go ahead and type them in the chat function, and we'll make sure to leave some time for them. Now, the written COVID-19 prevention program has these 11 different components to this. And before I get into the weeds here, it's important to note that even if your workplace does not have much experience with OSHA coming out to inspect and cite, COVID-19 related issues are a top priority for OSHA, understandably, in the current climate. And if there is a report of a number of COVID cases, it's very likely that the agency will come out and inspect. And they can learn of those cases. It could be by a media report. It can be from an employee complaint. It can be in connection with an inspection related to something outside COVID, such as a workplace injury. So it's really important that that you all develop a COVID-19 prevention program promptly, and that you conduct the necessary training and other requirements. There is recent guidance from OSHA saying that they will come out and cite you over the ETS requirements, but they won't issue penalties before, I believe, February 1st. So you have a very brief window right now here, about 10 days for that. But the key components of this program, just like with the injury and illness prevention program, is that you have a system for communicating with employees about COVID-19 prevention measures. Many of you already have these steps generally in place, so there's more specific requirements now under the ETS. You also need to have a system for identifying and evaluating COVID-19 hazards and for investigating and responding to positive cases. Once you identify the hazards, you're responsible for correcting those hazards, which could be, for example, a situation where you identify that there was an exposure at work because employees were not wearing face coverings, or they were working too close together, or there were just other circumstances about the configuration of the workplace. So a correction of the hazard could involve enforcing the face covering requirements. It could involve reconfiguring the workplace and a host of other requirements. It could also relate to training, and that's the next issue, is you are required to have COVID-19 training. You should have already been doing this before this ETS took effect, but under this ETS, you should really beef up your training program based on the components under the ETS and have essentially a retraining of your workforce. There's also a requirement for physical distancing in the workplace, 6 feet of separation to the extent possible, and that's a real ambiguity. There may be situations where employees can be a little bit closer, and that would really be a case-by-case situation to assess that. There's a requirement for face coverings inside the workplace and also outside if employees are less than 6 feet apart. Additionally, the ETS has requirements for engineering and administrative controls, and engineering controls would relate to generally to the configuration of the workplace. And that can be things that you can do. It can relate to the ventilation system. It can relate to physical distancing, how you structure the workplace. Administrative controls focus more on things like how you schedule shifts, that you might be able to organize the workplace in cohorts so employees are not interacting entirely, that you have separate shifts, so you have less potential for exposure. You can reduce the number of employees in the workplace. That would be effectively administrative control. And then PPE is personal protective equipment that can relate to face coverings. Really, traditionally, PPE might be something like an N95 mask and respirators. There's also requirements regarding reporting, and reporting these illnesses to OSHA would just be consistent with existing law. Essentially, when there is a inpatient hospitalization or a fatality for a COVID case that's work-related or occurs in the workplace. There's also requirements for recording these cases potentially on your OSHA logs, requirements for maintaining a shadow log internally of information regarding these cases, and also providing access to this information to employees in their union, if there is one. And then lastly, there's requirements for excluding COVID positive cases and also employees that are close contacts to positive cases from the workplace. And there's a really rigid requirement for when you can return employees to the workplace. So let's dive in. I know there's quite a bit of content in there. And then I think we can kind of jump through some of this. You know, the two major components of this rule that are probably resulting in the most questions that we are encountering relate to outbreaks. And so there's two categories of outbreaks. There's one that's just considered an outbreak, the other is a major outbreak. You're more likely to encounter the first outbreak situation. They have set this up so that if you have 3 or more positive cases essentially in a 14-day period, that would be considered an outbreak and require that you undergo a number of different steps. And what's important here is you're looking at the same cases in your exposed workplace. And the exposed workplace is where the positive cases are the work areas where they are that they are accessing or using. And so you're looking at not just the entire workplace, like a collection of buildings or the property. You might be focused on a particular building, or you might be focused on a department. And that's really a case-by-case determination that requires that you look at where the positive cases have gone and whether they can be considered to be in a finite area. It might be that the outbreak is just a floor of a building. It might be just a department, given various different considerations. And then once you determine that there actually is an outbreak, you're required to provide testing for COVID-19 at no cost. And you can provide that testing in the workplace. It has to be done immediately. And if that testing is done off-site, you're required to pay for the time for the employees to go get tested. And then there's a requirement to exclude the positive cases, close contacts from the workplace for a certain period of time. There's a requirement to investigate and make any appropriate corrections that are necessary as a result of the outbreak. And last but not least, you are required to notify the local public health department of that outbreak. And it's likely that the local public health agency will guide you through that process. Most of the local public health agencies are constructive in working with you on the situation, providing you tips through the process. And they may have their own requirements outside of what's in the ETS. And it's really important to be abreast of the healthcare orders and directives coming out of the local health agency. Now, for a major outbreak, it's fairly similar to a regular outbreak, except it's triggered when there's 20 or more cases in a 30-day period, so it's a pretty high threshold. And there's a requirement there, you know, under the outbreak standard, you're required to do weekly testing in the workplace or outside until there are no cases for a 14-day period. For the major outbreak, it's a requirement for twice a week testing. You have similar requirements for excluding employees from the workplace, hazard investigations, notifying the local health agency, and then also requirements for ventilation and improving air quality where possible, and considering closure and additional controls as appropriate. So let's move to the next slide. And the idea is to provide you a teaser on this issue and identify the major concerns for you to consider. And then if you have further questions, then you can attend the webinar that we have next week. So what we did was we put together kind of the top 10 issues, reminders for the ETS standard. So what's important to note is this standard is evolving. It's a temporary rule. And there could be amendments to the rule. It could be adopted as part of a permanent rule. If that occurs, given that the pandemic will end at some point, it could be replaced with a general rule on infectious diseases that's not limited to COVID-19. And as I mentioned, as for number 9 issue, the penalty issuance will be delayed through February 1st, but there is no delay in issuing citations. So you could receive a citation under this ETS. So it's important for you to make sure you have that COVID-19 plan in place and that you're abreast of the basic components of this rule. The industry-specific guidance is still helpful, but it's not the law, and foreseeably the agency could deviate from their own guidance if they choose to. For number 7, we do recommend that you review the frequently asked questions that are on Cal OSHA's website, and that's the Division of Occupational Safety and Health, excuse me. And so they have a number of FAQs. They've just updated them with even more guidance. And so you can review those to get a little bit more flavor of what they claim they're intending by this rule, given all the ambiguities and consistencies. And it's important for you to continue to assess work relatedness. So even though you have a COVID-19 case in the workplace, just the fact that you have that case, you shouldn't just assume that it's work-related. We highly recommend that when you have a COVID-19 case as part of your investigation, you complete a detailed assessment of that case to determine what potential exposure there may have been in the workplace given contact with other employees and what COVID-19 prevention measures are in place, as well as considering exposure outside of the workplace. And that can come from household members of this employee testing positive for COVID-19. And the work-relatedness is important for determining whether that illness must be logged on your OSHA 300 log, and also whether, if there is an inpatient hospitalization or fatality, whether you need to report that circumstance to Cal OSHA, to the Division of Occupational Safety and Health. And then the work relatedness is also a consideration for salary continuation. When you have an employee that's excluded from the workplace for it being a close contact with a positive case or being a positive case, generally you have to provide salary continuation with some exceptions. But if it's not work related and you can establish that for the positive case, you can make the determination that you do not need to continue salary, at least under the ETS. Also under 5, consider cohorts, other ways to reduce exposure. So if you have, very clearly delineated shifts and you don't have all of your employees overlapping, that's a way to really reduce exposure, avoid an outbreak situation. And that may be, for example, evident in not having all of your workers use the same break room. There are some local public health agencies requiring that employers shut down their break rooms, but you may want to either not keep the break room open, you may want to have different break rooms for different categories of employees so that those that do not work together are not having a reason to interact in the break room. And then, as I mentioned, you have shifts where you can have employees from different shifts not interacting where feasible. So there's a variety of different means that can help you here. You're also required to evaluate and reevaluate the workplace as conditions evolve to ensure that you have and continue to have effective COVID-19 prevention measures. And then consider obligation to pay excluded employees along with other leave obligations. So there is a requirement in certain circumstances to pay employees who are excluded from work. There may be obligations to provide a leave of absence for employees, and those are fairly nuanced issues. And then it's also important to understand the overlapping notice requirements under the ETS standard, as well as the AB 685, which was passed by the legislature. And it's unfortunate that we had the legislature passing one law, and then you have the emergency temporary standard that are basically not consistent. And that's been a bit of a struggle for employers. So, and just very clearly for the ETS standard, there's a requirement to provide notice to employees that are close contact with employees that test positive during the infectious period. The AB 685 has a different standard that I'll get to in one moment. There's also requirements for notice under SB 1159 that relates to workers' comp reporting. Oh, and then of course, we're going to promote our webinar. We'll have our webinar next week and we'll have more detail on all of this. So then moving to the next slide, we'll go right into employee exposure. And we just have a couple slides on this, and then we'll transition into the other employment-related considerations. So for AB 685, there is a requirement to provide written notice of potential exposure. And unlike the ETS, this notice is not just to close contacts, but it is to employees that are in the same work site. The same work site is like the definition of exposed workplace under the ETS. It can be narrower than the actual general work site where employees are working. But you provide notice to employees that are in that work site during the infectious period, whether or not they were in close contact with the positive case. You need to provide certain information to employees in that communication about COVID-19 benefits, disinfecting, and safety plan. And then notice to the employee's union, to their exclusive representative with similar information, but then also information that would typically be on the OSHA 300 injury and illness log. And notice to employers of, or essentially other employers in the workplace. So actually, I'm sorry, it's employers of subcontractors, not just any employers in the workplace. So let's move to the next slide. And there's also a requirement under AB 685, very similar to the ETS, about reporting to the local public health agency. There is some additional detail under this law about what information should be provided specific to the name, number, occupation of employees at the workplace, the business address, and there is a requirement to maintain these records for 3 years. And AB 685 does also allow OSHA to shut down your workplace if they find that given COVID, there's an imminent hazard. That's something in the discretion of the agency, and that would likely arise if there is, a significant unabated outbreak. Let's move to the next slide. There are some questions coming in on this. I'm going to save those for the very end so Megan is able to cover her issues. But very briefly, the last major COVID-19 law that generally applies to employers relates to workers' comp reporting. And there is what they've defined as a disputable presumption that COVID-19 is compensable for workers' comp purposes, where the positive test occurs during an outbreak. And an outbreak, unlike the ETS, or really it's unlike the ETS, is not specific to the number of cases, but is in reference to the number of cases within the workforce based on the total number of employees in the workforce. And so you see the definition there that outbreak exists if within 14 calendar days any of the following occurs, which is if you have 100 or fewer employees, you have 4 positive tests. If you have more than 100 employees, then it's if you have 4% of your workforce testing positive within this 14-day period. And lastly, it's an outbreak if it's simply ordered closed by the public health agency or just considered an outbreak by that agency. Now, let's move to the next element. And so I think we can just cover this briefly. You'll have this in the slides, but essentially when you have a positive case, you're required to presently report that case to your workers' comp claims administrator within 3 business days of learning that employee is tested positive. And so there's also a requirement when you reasonably should know that employee is tested positive. So if you're not adequately tracking these cases, that could be an issue. And so we've listed below the information that you need to provide that carrier or that claims administrator. It's essentially that you have a positive case, you don't disclose the personal identifying information, you indicate the date the employee tested positive based on when the specimen was collected for the test, you indicate the address in the workplace and the highest number of employees at that workplace within a 40-day period. Now, I think let's move to the next slide. And actually, I'll turn it over to Megan to cover the next topic.
Thanks, Andrew. So with AB 685 and SB 1159, we've transitioned into all the new California legislative changes that are now in effect. Some of them went into effect earlier than January 1 of this year, and those are noted throughout the slides. But the first one that we're going to talk about is SB 973, which requires private employers with 100 or more employees submit annual pay data to the California Department of Fair Employment and Housing. And the initial deadline is coming up March 31st, 2021. So just over 2 months away. And then it's an annual submission requirement after that. And there's fairly specific requirements for the pay data that needs to be submitted and how it's to be submitted. The DFEH essentially wants it to be searchable and essentially wants the number of employees by race, ethnicity, and sex identified in 10 separate job categories. And then they want them separated out within each of the pay bands that are used by the U.S. Bureau of Labor Statistics. And so they intend to issue a standard form for employers to use to submit their pay data reports and provide a submission portal to do that. And this is going to be similar to the now suspended federal EEO-1 pay reporting requirement. And we do know that the DFEH specifically wants this pay data in order to assist them in identifying discriminatory pay practices. So since employers who fall into this requirement will now be submitting this information, and this information, is available to the DFEH, but it now may become discoverable, say in private litigation involving a pay discrimination claim. It's a really good opportunity and a really good motivator to do an audit of pay practices to identify any issues that might need to be addressed before submitting that data, or continuing to be mindful of this issue going forward, knowing that this is an annual requirement and something that the DFEH has prioritized for reviewing themselves. As Andrew mentioned in the agenda, we have a further evolution in the independent contractor test that applies in California. The evolution began back in 2018 with the Dynamics decision, under which the California Supreme Court adopted an ABC test for determining whether workers can be properly classified as independent contractors rather than employees And just as a reminder, that ABC test essentially requires 3 factors: that the worker is free from the control and direction of the hiring entity, that the worker performs work outside the usual course of the hiring entity's business, and that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So when the ABC test came out in Dynamics and then adopted, largely codified with last year's AB5, it became in some ways more difficult to properly classify a worker as an independent contractor, because those 3 requirements became strict requirements rather than the previous rule that applied under most circumstances, which was a multi-factor test under the Borello case. And that was a balancing act. Rather than requiring all of the factors be met, employers could look at the factors and on balance make a decision about whether a worker could be properly classified as an independent contractor. What AB5 also did, apart from codifying the ABC test, is providing a slew of exemptions or exceptions to the rule, where if those exceptions were met, the Borello test rather than the ABC test was the deciding factor on, or the test to apply in determining whether a worker could properly be classified as an independent contractor. Now, not surprisingly, AB5 caused a lot of confusion and was the result of a lot of specific lobbying efforts, because you saw exemptions for certain industries and an absence of exemptions in other industries. And so for this new legislative batch, we had two assembly bills, 323 and 2257. 2257 updated a number of exemptions that existed under AB5 in order to try to make them more workable. I can't promise that they've made them less confusing. These are specifically exemptions for kind of business service providers, referral agencies, and business-to-business relationships. And the way that a lot of these exemptions work is that a number of conditions have to be met in order for the exemption to apply. And then if the exemption applies, you still have to go through the analysis of the Borello multi-factor test to determine if a worker can be properly classified as an independent contractor. And then AB 2257 also recognized a number of specific additional exemptions. A lot of these are for occupations in performance arts and journalism. And there's a whole slew of occupations that have been added. We've included some of the list, some on the list on the slide right there, but this is really a very fact-intensive and kind of really case-by-case analysis that has to that you have to go through to figure out if this helps in terms of classifying workers or not, and if your business needs to make any changes to come into compliance. AB 323 was a specific expansion and extension of the exemption that applied for newspaper carriers. So that was just a kind of a one-off. And then the other thing to keep in mind with independent contractor status is that we know from there was a lot of news coverage about how AB 5 did not cover anyone in the app-based transportation or delivery drivers, the Uber drivers and the Postmates drivers, that they were not covered by AB 5. And so we saw Prop 22 on the ballot, and on November 3rd, the voters approved Prop 22. So now, apart from the AB 5 or 2257 analysis under Prop 22, app-based transportation and delivery drivers can be considered independent contractors if they meet certain conditions. And those conditions cover everything from, minimum wage requirements, limits on working hours, certain requirements for healthcare subsidies and insurance coverage, anti-discrimination and sexual harassment policies. It requires some training requirements be met. It also requires zero tolerance policies for driving under the influence, as well as criminal background checks. So that's the current status of the independent contractor. One thing I will add that's not in the slides is that there was a California Supreme Court decision that came out last week. I believe it was. There was an open question when Dynamics came out about whether it would be considered that the ABC test applies retroactively or not. The Cal Supreme has now spoken on that and said, yes, the ABC test would apply retroactively. One last note on the independent contractor status is that because it is nuanced and continues to be, those exemptions continue to be confusing and require quite a bit of analysis. It's certainly a good exercise to go through if you are classifying workers as independent contractors to make sure that they still qualify under the current scheme. So moving on to some wage and hour developments. We've seen past years have covered a whole slew of updates. This year they're fairly narrow. There's two kind of exemptions that have been created that are industry specific for the general rule against having on-duty or on-call rest breaks. We had a big California Supreme Court decision back in 2016 that was in the security services context, but made pretty clear that for non-exempt employees entitled to a whole slew of wage and hour protections, including rest breaks, that those rest breaks cannot be on duty or on call. So you can't have a situation where, the employee is taking their rest break, but they have to, carry around their cell phone and answer it and potentially be called back to work. That typically is considered to be a violation of the rest break requirement. However, AB 1512 created a very limited exemption for certain security guards. It's only applicable through January of 2027. And it requires that the registered security services officer be covered by a valid collective bargaining agreement. And that agreement has to meet really specific conditions that cover and that provide for rest periods, that provide for arbitration for rest period disputes, that provides for premium pay for overtime hours worked, and specifically provides for an hourly rate of pay that is higher than the state minimum wage. It has to be at least $1 more than the state minimum wage. But if all of those very specific conditions are met, then you can have a situation where a worker may be required to remain on the premises and remain on call during their rest periods. The idea would be if a security officer had a rest period that was interrupted, that they should be permitted to restart the rest period as soon as practicable. And if they're not allowed to do that, that they would still be entitled to the 1 hour of premium pay for missed rest periods that generally applies when a rest period is either not provided or not provided correctly. The second exemption to the kind of Augustus rule against on-duty, on-call meal breaks is for certain safety-sensitive positions at petroleum facilities. And this exemption exists through January of 2026. It has a similar requirement for a valid collective bargaining agreement, though there the pay requirement is not less than 30% more than the state minimum wage. And there, if the conditions are met, a worker can be required to carry and monitor a communication device. And similar requirements exist if they're not able to retake their rest break at a later time. Just a couple more wage and hour updates. AB 2588 basically specifically says that there's a current law, apart from AB 2588, current law requires employers to reimburse employees for necessary business expenses. And so 2588 specifically says that employer provided or employer required kind of educational programs or training for an employee who provides direct patient care for general acute hospitals and applicants for that same sort of work, that those are reimbursable expenses. There are some limited exceptions to that, but that's on the reimbursable expenses front. And then on the public works prevailing wage front, we have an expansion of the definition that basically includes construction, alteration, demolition, installation, or repair work done under private contract, but on a project for a charter school, where the project is paid for with certain funds, that still falls under the prevailing wage law, and prevailing wages would have to be paid on such a project. So that's just an expansion of when the prevailing wage laws would apply. And then AB 3075 requires that business entities who are required to file their annual statement of information with the Secretary of State are going to have to specifically disclose whether any of their officers or managing members have an outstanding final judgment for essentially a labor code or wage order violation. And they're supposed to do this either by January 1, 2022, or upon the Secretary of State kind of implementing its specific California Business Connect program. And then those individuals will have to disclose any wage and hour, essentially wage and hour or labor code judgments. The next topic, like Andrew mentioned, is one more pretty narrow exception to the general rule against no rehire provisions in settlement agreements. The history here is that last year we had new legislation that generally prohibited employers from requiring, in the course of settling a dispute with a worker, that restricting that employee from obtaining future employment with that employer. And this legislation kind of came out of a Ninth Circuit Court appeal where there was a dispute over how broadly no rehire provision could be in a settlement agreement. And the Ninth Circuit came down pretty strongly that limiting a worker's ability to work for that employer in the future, or even a parent company or a subsidiary or an affiliate, was essentially a violation of California's non-compete law. So you have to pay particular attention when, especially in finalizing settlement agreements, entering into settlement agreements with employees, and restricting their ability to be rehired with the employer, that you're not in violation of the current law. And there was a carve out last year for an employer if they've made a good faith determination that the worker engaged in sexual harassment or assault. And now we have AB 2143, which adds an exemption where the employee has engaged in criminal conduct. And there's some nuance to the applicability of the exemptions, and that there kind of has to be a determination from the employer before the employee files a claim so that they can establish the applicability of that exemption. But that's just something to keep in mind. It's good if you haven't already reviewed your settlement agreements to keep this no rehire ban in mind. On the discrimination and harassment front, we've seen an expansion of the statute of limitations, the time that an employee has to file a complaint with the state labor commissioner for wrongful discharge or termination. Rather than the 6-month statute of limitations, employees now have 1 year. It also specifically amended the labor code section authorizing a court to award attorney's fees to an employee who prevails in showing employer violated anti-retaliation protections. So that's just a brief little update on the discrimination harassment front. On the topic of leaves, we have a pretty significant expansion of CFRA, the California Family Rights Act. Typically in California, we've thought of CFRA and FMLA, the federal FMLA, together as kind of applying to larger employers with 50 or more employees. But now under SB 1385, CFRA applies to any employer with 5 or more employees. So even employers that didn't have to think about CFRA before or may not have been tracking CFRA, now is the time to really look at this new legislation and review handbook, leave policies, protocols for managers and how to handle leave situations to make sure you're accounting for this this expansion in the CFRA leave. So in addition to reducing the threshold of how many employees you have to have for this to apply, there's also no longer any geographic limitation. So before, if you had, maybe you were an employer with 50 or more employees, but you had one site where, you had a handful of employees and they didn't reach that geographic limitation of having 50 employees within a 75-mile radius, that geographic limitation no longer exists. Likewise, there used to be a restriction where if you had parents that might qualify for baby bonding leave under CFRA and they were both employed by the same employer, you would be able to restrict leave to either one parent or split the leave between the two parents. That restriction no longer exists. So now if you have 2 parents employed by the same employer, they're each entitled to separate CFRA leave. There's also been an elimination of the key employee exemption, which played a role in employees' right to reinstatement. So we really kind of have to shift our thinking on CFRA and realize that there's now greatly expanded right to those 12 weeks of unpaid protected leave during any 12-month period. And just as a reminder, the categories for CFRA leave generally are for reason of the birth of an employee's child or placement of a child with an employee for adoption or fostering. So that's what we think of and what we speak of as kind of the baby bonding aspect of it. And then there's also the ability to take CFRA leave for an employee's own serious health condition. In California, there's kind of a carve out for pregnancy. Pregnancy is dealt with a little bit differently. And then there's also an ability to take CFRA leave to care for a child. And I'll point out that this is where there's been a great expansion as well, because child now can include children over 18 under certain circumstances. Parent was always there, but now grandparent, grandchild, and sibling are covered. Spouse and domestic partner was included before. And so the important thing to note about the expansion of the family members that are now included is that you could have a situation now where an employee's CFRA leave and an employee's may not run concurrently with an FMLA leave. So you could, conceive of a situation where somebody took CFRA leave, say, to care for a grandparent, which was covered under CFRA but not FMLA, and then maybe would qualify for FMLA leave to, say, care for the employee's own serious health condition. So another thing to keep in mind is that kind of the qualifications to apply for CFRA leave, in that it still exist, in that an employee has to have worked for the employer for at least 12 months, and they have to have worked at least 1,250 hours in a 12-month period. So that qualifying requirement of CFRA still exists. Now, one other little nuance of the CFRA expansion is that a couple of years ago, 2018, we had a new Parent Leave Act that allowed for baby bonding for smaller employers. That has now gone away and is included in this CFRA expansion. So that no longer needs to exist because it's now covered with the new CFRA law. So there's also CFRA also includes leave due to a qualifying kind of military leave for covered active duty or a call to covered active duty for an employee's spouse, domestic partner, child, or parent in the armed forces of the U.S. And speaking of military leave, there is a separate assembly bill that covers expanded military leave that, if that applies, you can review the slide on that. For expanded, for leave for victims of crimes, there's been a small clarification that basically says, when the leave can be taken and for what purposes. So that's also good to keep in mind so that you know all of the qualifying reasons for the leave. In case you thought you were done with the COVID updates, I'll just briefly cover a COVID-19 paid sick leave issue that with the expiration of the Federal Families First Coronavirus Response Act and the California Supplemental COVID-19 paid sick leave, it's really important that employers track if there's any local ordinances that provide continued COVID-19 related leave now that the federal and California-wide COVID leaves have expired. Now, some employers have decided to continue their supplemental leave to take advantage of some tax benefits under the FFCRA, but in case an employer is not doing that, they'll want to track any cities or counties that may have local ordinances. We know that these ones exist and there have been some expansions, so there may continue to be an evolution of this. And it's also really important to look at what the local ordinance specifically requires, because some have slightly varying reasons why you would qualify for a leave. For example, the Los Angeles ordinance is a little bit broader than the categories you might typically think of as qualifying for COVID leave, like being subject to a quarantine order or being advised to isolate or having health concerns related to COVID. Los Angeles also has some expanded qualifying categories for being a member of a vulnerable population, for example. So something to track. And one more thing to track is also the minimum wage increase, both on the California statewide and local level. California's minimum wage has bumped up at another $1 as of January 1, 2021 for larger and smaller employers. And many of the local ordinances have increases that take effect in January and July of a given year. So those are also important to track as well.
All right, well, thank you, Megan, and thank you all for joining us. We did want to kind of part with some information regarding our firm's resources that are available to you all. We have a COVID-19 task force and resources on our website. We also have blogs, both for employment related issues generally, and also for OSHA issues, and there's a kind of plethora of resources there. There were a couple, I don't know, Megan, if you could show the next slide there regarding our blogs. It doesn't have our employment blog, but we have that as well, of course. And there were a couple of questions I did want to address that related to COVID at the outset of the webinar. And one of the questions is really a good one, that is, are outbreaks considered part of the workplace even if the employee believes they got COVID from their personal home life? And so essentially the question is, if you have a COVID positive case, but you have reason to believe it's not work related, is that COVID positive case considered under the ETS for the purpose of determining whether you have an outbreak? You know, for example, that you have 3 positive cases within a 14-day period. And the answer is yes, that non-work related COVID case is considered for outbreak purposes. There's no exception. And so really the framework is whether you have those 3 cases within that 14-day period within the same exposed workplace. And there is some flexibility you have in determining what the exposed workplace is for that purpose. And there was another question, equally good, which was, can we make it optional for employees to use PTO or sick pay and then not need to pay them if they choose not to do so? And so the ETS makes clear that you can rely on other benefits like paid sick leave and public benefits. And so there is a little bit of ambiguity about exactly what you can do, but how I'm reading the requirements is that you can apply the employee's paid sick leave. And you can also consider any state benefits that are available, like SDI or paid family leave. So you'd want to encourage employees to apply for SDI and paid family leave. It's not entirely clear whether you can force them to apply for those benefits, but the ETS does make clear that employers may use employer-provided employee sick leave benefits for this wage continuation purpose and consider benefits available from public sources. But there is no provision to consider vacation pay, for example, to meet this pay continuation requirement. With that, we're concluding the webinar. Thanks again for attending.